Corinne Boudreau, and welcome to Certainties Law. This is video blog number 2 coming to you today from Platform Space in Bedford. Today I'm going to be talking about Cheesestrings and share conditions, two of my favorite things. Now, why would I be talking about share conditions? Well, I would suggest to you that creating different classes of shares and drafting the share conditions that go along with them are one of the core skills of a tax lawyer. So there's really 3 basic types of share rights. The first are voting rights, the second are dividend rights, and the third are rights to assets on dissolution or wind-up of the company. So, if you only have one class of shares, which are commonly called common shares, they, without saying anything else, would contain all of these rights. So if we come to the cheese string analogy, the whole cheese string would be common shares. So they have all the voting rights, the dividend rights, and the rights to assets on dissolution. If we start going through shares with different rights, they can have different rights in any 3 of these sort of broad categories of share rights. So for instance, with voting rights, if you were just concerned about splitting off control of a company, you could create what some people call thin voting shares or super voting shares. So in doing that, you're really just peeling away one small strand of the voting of the types of share rights that are voting shares. So there we go. The rest of the shares of the company would still contain the other rights that aren't in the thin voting shares. To dividend rights, depending on what you're trying to accomplish, you can certainly create different dividend rights attaching to a class of shares. So for instance, if you're just trying to move cash from an operating company to a holding company, just for purification purposes, you can just create dividend streaming shares, which just allow you to pay dividends from one company to another. Or in the most simple scenario, if you're trying to accomplish some income splitting, you could create discretionary dividend common shares, so that basically you can allow for sprinkling of dividends among the common shareholders, irrespective of how many shares they actually hold. Then if we come to rights to assets of the company on dissolution or wind-up, we certainly use fixed value preferred shares for different purposes, but they basically revolve around fixing the amount of a right that the shares would have to the assets of the company. So for instance, in an estate freeze, you're trying to soak up in one class of shares all of the current value of a company, and allowing the future value of the company to accrue to a set of common shares. Or if you're doing a Section 85 exchange of one type of shares for another type of shares, again, you want to make sure that the value of one class of shares is the same as the other class of shares. So you would fix the value. And certainly Canada Revenue Agency has other comments about what other types of attributes that the shares need to have in order to make sure that they retain their value for that purpose. Joining me today for my video blog on share conditions and cheese strings. Feel free to visit me at my website or provide any feedback or comments on this video. Until next time, the only 2 things in life that are certain are death and taxes, but for clients, I also aim to make price and quality the 2 other certainties. Thank you for joining me. Bye. Oh, I'm going to have a snack now. Thanks.